The issue of concealed carry bans has resurfaced on the national stage, finding its way back to the Supreme Court. The justices face a pivotal decision: whether to invalidate several state laws that have been enacted in stark defiance of the Supreme Court's ruling in the landmark case of Bruin. These laws, crafted in various states, have directly challenged the precedents set by the court, creating a complex legal landscape that now demands careful judicial review. This situation puts the Supreme Court at the center of a significant constitutional question concerning the Second Amendment and its application across diverse legal jurisdictions. As we delve into the current developments surrounding the issue, it's crucial to understand the implications of the court's upcoming decisions and how they might reshape the legal framework governing the right to carry concealed firearms in the United States. Let's explore the details of what is transpiring as the court prepares to address these contentious legal battles. You could also find more news and detailed analysis on our website, validsurvival.com. In this video, we will look into the ongoing legal battles surrounding concealed carry laws and how they intersect with the Second Amendment and the Supreme Court's Bruin decision. Notably, the issue is once more before the Supreme Court due to significant developments. Recently, the Second Circuit conducted expedited hearings for 5 cases challenging New York's Concealed Carry Improvement Act, CCIA, following a stern directive from the Supreme Court. This directive reminded the Second Circuit to adhere strictly to the principles laid out in the Bruin decision. The CCIA, a highly restrictive concealed carry law, was introduced by New York as a direct counter to the Supreme Court's ruling in Bruin. Remarkably, this new law was enacted just 8 days after the Supreme Court delivered a decisive 6-3 verdict. Now, the Supreme Court is ready to review these developments in a conference scheduled for early next month. They will decide whether to address and potentially strike down what many see as a defiant stance by New York against the Supreme Court's earlier decision. This session promises to be a critical juncture in the ongoing debate over gun control and constitutional rights in the United States. For those unfamiliar with the Bruin decision, the Supreme Court invalidated New York's original May issue CCW licensing scheme, ruling it inconsistent with the nation's historical and traditional approach to bearing arms. A key aspect of the Bruin ruling was the court's determination that the government must demonstrate that any firearm restrictions it imposes are grounded in historical precedent and tradition. Additionally, the decision articulated that a state like New York cannot broadly designate an entire state or large area as a sensitive location where carrying firearms is prohibited. Specifically, Justice Thomas noted that New York could not designate the entire island of Manhattan as such a sensitive location. Despite this ruling, only 8 days after the Supreme Court's decision, New York enacted the CCIA, which imposed even stricter regulations than those previously overturned. This new law quickly faced numerous legal challenges across various district courts. Some of these courts issued preliminary injunctions, temporarily stopping the CCIA's enforcement. However, New York appealed these decisions to the Second Circuit, a court perceived as less favorable to gun rights. Subsequently, the Second Circuit issued blanket stays on these lower court rulings, effectively pausing the injunctions and allowing the CCIA to remain in force while further appeals were considered. In response to actions by the Second Circuit, the GOA initially sought an emergency review from the Supreme Court last year to challenge the circuit's decision regarding the New York CCIA. Although the Supreme Court denied this emergency relief, it did instruct the Second Circuit to expedite its review of the cases or to provide a justified written opinion explaining why it issued blanket stays on lower court decisions. Opting to expedite rather than justify, the Second Circuit moved forward swiftly with the hearings. A significant moment in this legal saga occurred during the Antoniuk case, which presented a broader challenge to the CCIA, criticizing not only the permit process, but also numerous specific location restrictions imposed by the law. The Second Circuit eventually vacated several of the district court's injunctions that had temporarily halted the enforcement of the CCIA. In its decision, the Circuit Court labeled the Bruin decision as exceptional, thereby arguing that the precedent set in Bruin did not apply universally, thus ruling that the CCIA is constitutionally valid under the Second Amendment. Following the Second Circuit's decisions, the GOA has now filed a petition for the Supreme Court to review these rulings. This ongoing case remains in an interlocutory state, as it involves a review of preliminary injunctions and hinges directly on the interpretations and implications of the Supreme Court's Bruin decision and New York's legislative response with the CCIA. In their petition, the GOA highlights the wide range of opinions that have emerged following the Supreme Court's Bruin decision, particularly regarding the historical evidence needed to justify governmental restrictions like New York's CCIA. The GOA points out that some courts, such as the Second Circuit, have continued to accept more recent historical evidence to uphold such laws, challenging the Supreme Court's precedent in Bruin. The petition criticizes the Second Circuit for advancing the theory that it was not obliged to adhere to the Supreme Court's methodology in Bruin, claiming the decision was of an exceptional nature and therefore not a standard for less significant cases. The Second Circuit has repeatedly asserted this position, justifying its deviation from Bruin's framework by suggesting that Bruin was unique due to its particular circumstances. This stance has led the Second Circuit to treat the CCIA as non-exceptional and thus not subject to the stringent standards applied in Bruin. This interpretation is pivotal for ongoing and future legal challenges to similar laws, like those in California. For instance, in California, similar restrictive measures were enacted post-Bruin, such as SB 2, leading to legal challenges like those faced by the CCIA. The California Rifle and Pistol Association, CRPA, has brought a lawsuit against SB 2, which is currently under review by the Ninth Circuit Court of Appeals. During recent hearings, the Ninth Circuit contemplated aligning its reasoning with the Second Circuit's approach in the Antoniuk case, indicating the significant influence of the Second Circuit's interpretation on other judicial bodies handling similar cases. This situation underscores the broader implications of how courts interpret and apply the Bruin decision across different jurisdictions, affecting gun control legislation and the enforcement of the Second Amendment. In response to the petition, the state of New York has argued that the Supreme Court should decline to review the case at this time. The state contends that the issue is too premature for Supreme Court consideration because it involves only a preliminary injunction, and there are no conflicts among the circuit courts on this matter. New York's legal team asserts that the petition for certiorari should be dismissed initially, as the court typically refrains from interlocutory review. They emphasize that the Court of Appeals found that the plaintiffs failed to demonstrate a likelihood of success on the merits at the preliminary injunction stage, citing either a lack of standing or a lack of a substantial legal claim. The state suggests that further litigation could eliminate the necessity for Supreme Court intervention, and that a more thorough review would benefit from a fully developed record and a detailed assessment of the merits. New York's argument implies a strategy to defer Supreme Court review, suggesting that the matter should first return to the lower courts, where a final merit decision can be made, and only then, if necessary, should the Supreme Court become involved. Furthermore, New York points out that no petitioner has yet applied for a license under the challenged licensing scheme, nor has anyone been denied a license based on the criteria of good moral character. This, the state argues, underlies a significant gap in the petitioner's standing, as they have not been directly affected by the law's enforcement. This issue of standing was previously identified and addressed in the lower courts, but New York raises it again, suggesting that the petitioners lack the requisite standing to challenge the process, since they have not actually undergone it. The Supreme Court is now ready to determine whether it will grant review to the Antoniuk case, despite it being in an interlocutory phase. The case has been scheduled for discussion during the Supreme Court conference on June 6th. At this conference, the justices will convene to make a decision on whether to proceed with the review. Typically, the Supreme Court is hesitant to engage with reviews of preliminary injunctions, but the direct ties of this case to the significant Bruin decision may make it an exception. For the review to be granted, only 4 of the justices need to agree. There is a possibility that advocates of the review could persuade additional justices to support taking on the case. This is a development that many will be watching closely, particularly given its potential implications for similar cases nationwide. Additionally, A nod of appreciation is due to the GOA for their continuous efforts in this legal area. Thank you for watching the video, and that is all for this one. If you find this video helpful in any way, give a huge thumbs up. Stay tuned for the upcoming videos by subscribing to our channel. See you guys in the next one.